I'd like us to go into this session, and I'd like us to understand what is happening this afternoon. We are all practitioners in the industry, but there is no industry that doesn't have a regulation or laws that regulate the industry. And for us in the industry, one of the most important laws that manages what we do and manages our creative economy is the copyright laws that work in the country. As it is now, we have a copyright law that has been in existence since 2001. It was enacted in the year 2001, and we are right in the process of amending this very archaic law. Now, as you all know, there's a process that a law goes through in Bunge so that it is enacted from becoming a bill to becoming an act or law. And as we speak right now, the Copyrights Amendment Bill has already gone through the first reading in Parliament. It has actually gone through the second reading. And in fact, on Tuesday, we were receiving memoranda from interested people on issues that they would like to raise on the amendments that are proposed for the new law, the new copyright bill. And that's one of the reasons why we are here today, so that we can listen to what stakeholders in the industry have to say about the amendments that we want to enact on this copyright bill. Now, you've got to think about the time we are living in. When you think about it, in the days of our forefathers, the biggest asset or raw material that you could think about was land. Because they used land as a means of production. You could plant on the land, you could have animals on the land, you could graze on the land, but those are days gone by. That's in the days of our forefathers. In the days of our fathers, there was industries, there was factories. People would work in factories, people would work in industries, and they would produce tangible stuff. But in the generation we're living in, I want to put it to us here that the most important thing that we have going for us is ideas. We are in an ideas economy. So what we want to discuss is how do we protect these ideas by law. So much so that if you come up with a novel idea, you're able to capitalize on that idea, you're able to make that idea lucrative enough to be a means of living. So kawe ni msanii, you know before you write a song, before uweke hizo 16 bars kwa karatasi, before uingie studio record hiyo ngoma, before hata uunde hiyo music, write hiyo music yako, the first thing is that you have to have an idea. Now the whole idea of protecting intellectual property is seeing how, if you generate a novel idea, an innovative idea, a new idea, how it can be protected in such a way that it cannot be taken from you and exploited by someone else. So with us on this panel this afternoon, we've got the right people. And by the right people, I want to believe that even you who's seated there, you've got something that you can contribute to the discussion this afternoon. And you shall have an opportunity to say a thing or two about what you think regarding the Copyrights Amendment Bill of 2017. But before we do that, I'm going to call up able discussants to just give us an overview from the different stakeholders concerning this bill. And the first person I want to call up, I know it's not a performance, that's why I'm seated, but I think it will be in order to just give them a fitting a round of applause when I call them up. So, ladies and gentlemen, this afternoon, the first discussant I'm going to call up from the Kenya Copyrights Board. Please give a fitting ONGEA welcome to the one and only Paul Kiarie. Kaindo.
Yeah. Thank you, Honorable KJ.
So Paul, what I want you to do is just give us an overview of what necessitated the revision or amendment of the Kenya Copyrights Bill of 2001.
Thank you very much. Now, the main reason why it became necessary for us to have the Kenya Copyright Act amended is, of course, very clear. This act, like Honorable KJ has said, it is 17 years old. A lot of things have happened between 2001 and now. So it has become necessary to move with time. And you may realize that copyright these days, artists are now commercializing their work through the internet. So that is why it became necessary, because the old act did not actually envision that situation where artists are actually doing things in the internet. Now it has become a reality. So it became necessary for us to rethink of the laws that exist as they are and change with the time. However, if I could just mention the main general objectives of the amendments is simply to expand the scope of the copyright protected, to ensure that copyright holders are actually protected in other areas other than the areas that are provided for in the current act, and also to extend protection in respect to broadcasts, promote sound corporate governance, and improve efficiency in royalty collection. You know very clearly what has been happening with royalty collection. We have been having a lot of problems with royalty collection. So it became necessary for us to amend the law, because the previous law, we could do so little. There is nothing much we could have done. But now, the new law now requires us to, or enables us to give the Kenya Copyright Board teeth to be able now to take action wherever there are issues of royalty collection. Now, there are several sections that have been amended by this bill, but most importantly is the fact that it needed, the previous act had a lot of issues that were not clear. So one of the main reasons was to clarify some provisions, as well as ensure that you guys are protected in other areas like I've said. But most importantly, ISP liability. These days, like I've said, and I want to repeat again, artists are commercializing their work through YouTube, through other areas. Safaricom recently launched some program for streaming. Now, that requires now the laws to come in to be able to protect the rights of the right holders in that platform. The previous law did not actually provide for that. We are way behind the age where people are selling their CDs to make a living, or selling your work in flash disks. That is a period that is actually gone. The previous act actually was just revolving around that area. So it has come in to expand that provision. I don't want to go to specific sections, but I really need you to look at the act, look at section 2, section 5, section 11 on the appointment of the executive director. Now that opens up the field for anybody else other than an advocate, because the previous act only required an advocate. But if you are an expert in, you have training in intellectual property, now you can actually become an executive director of the Kenya Copyright Act. Look at section 26 on fair dealing. That section clarifies what amounts to, clarifies the nature of copyright in musical, literary work, in audiovisual works. What rights does a right holder owns? And what, it also mentions issues relating to fair dealing. Yes, you have those rights, but there are some instances when somebody can, let me not use infringe, but use your work without necessarily infringing. So section 26 came to clarify and clear issues where it would actually enable people to use your work without necessarily being deemed to be infringing. Section ISP liability, I've mentioned that, and also CMO provision, section 46. Now Kenya Copyright Board will have a say in the running of the collective management organizations. Collective management organizations are the ones that you're seeing represented here, PRiSK, KAMP, and MPAKE. Now Kenya Copyright Board will have a say within the running of those organizations. Of course, there are people who are really against that, saying these are private rights, we should not come in. But Kenya has a unique character. When you give them something, they want to pick, they don't want to consider anybody else. They want to take everything to themselves. It became necessary for the government to be involved therein. That is, in a nutshell, the reasons why we found it necessary to amend the Copyright Act. Back to you, KJ.
Thank you very much. Much appreciated. I think he deserves a round of applause. And what we will do is that at a later stage, we're going to just give you the opportunity to ask questions to Paul if you would need clarity on a few things. And here I'm going to give a bit of latitude to just not limit the questions to the bill that is at hand, but also to the mandate of KECOBO. So if you're sitting here, you're a creator, you're a performer, you're a probably potential intellectual property owner, you need to understand that there is a board that is constituted by law in Kenya to protect your works, whether the works are visual arts, whether they are performing arts, and that board is called the Kenya Copyright Board. Now, as the law sits today, the executive director of KECOBO can only be a wakili, as it sits today. And the bill that we are proposing, the amendments that we are proposing, need to expand this so that any intellectual practitioner or intellectual property practitioner can stand a chance to be a director, as one of the biggest takeouts out of Paul's presentation. Ladies and gentlemen, I want to quickly welcome from the Kenya Association of Music Producers, the director of KAMP, or one of the directors of KAMP, the one and only Lee Kanyotu. Let's appreciate him. Lee Kanyotu, kindly talk to us about how KAMP is going to interact with these amendments in the new act.
Asante sana mheshimiwa John Kiarie. Siku hizi artist anaingia kwa studio, anajirecord, anajimarket, so he owns the master. In copyright it's written there, owner of sound recording. That's what basically it means. I'll try not to be very complicated in explaining some of these things. So why is Kenya Association of Music Producers interested in the amendments? Just as you've rightly said, Mheshimiwa, copyright basically is just what you've said. It's all about protecting our ideas. So in music, as you've gone through the whole thought process and now you have your music, how are you going to monetize the music? What rights do you have? And actually what happens is that in a CD, we usually put C with a circle, all rights reserved, you know? Those guys who used to sell CDs. Then would say what? Unauthorized, copying, duplication. I'm just a CDs, I'm a cassettes. They are digital.
Digital
that's why we're doing this amendments.
Pirate na download.
But the CDs are written those things. Unauthorized public performance and broadcasting. Really, those are statements of the rights that you have in your music that you want to protect and you want to authorize and prohibit. So just a bit about Kenya Association of Music Producers. This is a collective management association. As we have said, as Paul has also rightly said, that it's basically a music licensing organization. So what we do, we manage the rights collectively of our members who, as I've told you, are record labels and even independent artists who have signed up with us so that we can go and look out at areas where the music is being exploited by customers. It can be the broadcasters, in the transport, even in the like here, hotels, supermarket, and so on. So for us, the section that touches on the rights of music producers, and when I say music producers, at times copyright is also a bit complicated, because I know that the music producers who even have got stands here, like Mosioka, I know is somewhere here. So that's more of a creative, and that falls under PRiSK, because they will make for you the tracks and arrange for you the tracks, okay? But the music producer I'm talking about is the one who, at the end of the day, invests in that creative work and later owns that work. I hope I'm clear on that, just the definition, so that people are not getting confused. So it falls under Section 28. And one of the things that we have seen is that we're not selling music, as you've rightly said. Myself and many other producers who had shops in River Road had to close them. Even I don't know how one of our founders, Director Kasanga, is still surviving in River Road. Everyone knows the 2 CDs. So it's been tough trying to do business in this technological, with the technology that is there, the digital environment. So one of the things that we are pushing for in the amendment is to have a protection in the digital environment. And it's by adding one right that all over the world has been accepted. It's called making available right. Because what is happening right now is that your music is being available in the internet quite fast, and people want to download your music. So we need to protect it. So it's an exclusive right which enables you as the owner of music to be able to allow and also prohibit the use of your music in the digital environment. Other things that we also concerned about that needs to be adapted, since the copyright amendment was, the copyright bill was quite old, is even the definition of a publication. It's still old. The publication those days did not foresee the development that was coming, the digital environment. So we have also submitted as Kenya Association of Music Producers to have the definition of publication that is found in Section 2, just to revise the words so that it can incorporate the works in the online and digital environment, which is very key, so that we can monetize our work and protect our work in the environment. Other than that, also another one that we are, I won't go into details because we have sent a memoranda to the parliamentary committee, and we'll hope to, with our legal team, able to dissect it further and also share with our fellow CMOs, because we haven't even sat down to to align ourselves in what we want and what we do not want. Yeah, so another one is what we call equitable remuneration. That was a heated debate sometime last year. Was it last year or last year but one?
It has always been a heated debate.
It has always been a heated debate on what equitable remuneration is and how is it been applied. And basically that right to the performer, which basically means that as long as you have sung or as long as you have performed in a song, at least you need to be compensated. That's what equitable remuneration talks about. And for us as producers, we've recognized that, because like myself, I can say an instance is that we represent old music also from the 70s, and some of our contracts did not also foresee the technology. So this is some amendment we want to put in the Act to try and correct some contractual deficiencies that we had, so that when we're exploiting some of the old music, or even some music that is currently being produced, because some people are producing without contracts and agreements. Mmeingia tu studio, mmekolabo, mshenda kwa nini, kwa YouTube, inaanza kupata ma-views, mmeregister kwa CMO, royalties inakam, then mnasema, by the way, hii song ni yangu. Then another person, hapana hii song ni yangu. Then what happens there? So we want to at least have something that would be able to help that contractual dispute to say, okay, as long as you're the producer and the performer, you'll still get something. We want to protect your performance, your creative. So in a nutshell, so I don't talk so much, and there are more people, maybe Dan ataweza kuimba. And Dan pole, Dan is a digital guy. Siko ubani kuna karatasi. Usually tells me, "Wa, achana na karatasi." My phone died. So having said that, I know as we continue, if there are more questions, we'll be able to clarify. Yeah. Thank you so much.
Wow, appreciate him. Let's just give him a round of applause. Just by a show of hands, are there people here who are members of KAMP in the audience? Thank you. Thank you. Are there people who are producers in that other sense, the other sense that, that Lee was defining? Producers kama Sioux, kama, yeah, I see. Thank you. Thank you. Kindly stay to the end. There are some few things that we would like to hear from you. But in the meantime, because Lee brought it up, I'd like to say that we are in the presence of greatness. I'd like to let you know, the digital generation, that before there was the beat, before there was crossover, before there was Tukuza, there was something called Joy Bringers back in the day. And I want to tell you that the pioneers were as revolutionary as the modern day gospel singers. I know we always say, hii gospel ya siku hizi, sijui imefanya nini, hata hao walikuwa naambiwa hii gospel ya siku hizi. That time, I know one of the most amazing stories I ever had is that this man I'm just about to introduce had a problem introducing a guitar into gospel music. Ladies and gentlemen, in the presence of greatness, I'd just like to acknowledge the presence of the one and only Mr. Kasanga is with us in the house. And he needs to tell us how he stays this young. Right now, just so that I can break the monologues and the soliloquies, I'd want to focus our attention on the screens. As I told you, this bill is currently in the process in Parliament, and on Monday, a committee, a departmental committee on communications, information, and innovation will be considering the memoranda that was presented by Kenyans through the process called public participation. And after that process, the amends that are being recommended will be relooked at. But I want us to focus on the screens.
Let's have the Honourable Member for Dagorreti South, Honourable John Kiarie.
Thank you very much, Madam Speaker. I really appreciate this opportunity to rise and support the Copyright Amendment Bill of 2017, which in itself is a bill that seeks to amend an Act of Parliament, which is the Copyright Act of 2001. And on the onset, I'd like to note that entertainment and the creative economy in Kenya is a multi-billion Kenya shilling industry. And as such, this bill is very timely. I know that we will all agree that ideas are going to become the currency of the new world. The new world belongs to men and women who will be coming up with great, novel, and exemplary ideas. And our recent history is replete with examples of great men of great ideas who have contributed in a massive way to the development of our globe. I know names like Bill Gates will come to mind with his idea of a computer on every desktop. A man like Steve Jobs, he of the Apple fame. Mark Zuckerberg, who recently visited Kenya, is a man who created the largest country by population in the world today. And the world that he created, or this country that he created, is actually online, does not exist anywhere physically. By virtue of the population of people on Facebook today, Facebook is the largest country in the world today. And so, ideas are going to be the biggest driver of development of the globe going forward. This House is also not short of examples, and Honorable Jaguar from Starehe constituency comes to mind, the Honorable Moha of Jichopevu, and of course the Honorable Member of Parliament from Dagorreti South, all who have plied their trade in the creative industry. They do come to mind. And it is to such minds of great ideas that the future belongs. I know that the Bible does remind us that we are co-creators with God. And as such, the environment that God did not create naturally, He left for us to co-create with Him. And hence, the need for us to look into this industry of idea creation. Well, It has been said by my colleague and senior, Honorable Cicely Barire, that if we were able to amend this bill and put it out there, we shall actually be availing opportunities, because we realize that not all our young people will get employment opportunities in government. Not all our young people will be employed in companies. But if we widen the scope of tapping talents and making them an industry that pays our young people, we shall be availing Bill 6 to do. I rise to support it, and as I support it, I want to add there that I see an opportunity for us to expand how we view creativity, to go beyond what was traditionally the visual and performing arts, as most members are contributing. There are new worlds that beckon, great opportunities that are out there. These opportunities are in the new and emerging industries of information technology. Great opportunities for creative ideas to thrive. And with that, I would like to say that unlike what has been said by the Honorable Member of Kisumu East, I'd like to say that I do not find the penalties here punitive. Because some of the offenders of copyright rules are actually multinational corporates. Multinational corporates that will take conceptual ideas, intellectual property of young Kenyans, exploit them to make billions and billions of dollars, while the creators suffer and linger in poverty in this country. As such, I do support stiffer penalties for copyright offenders, be they multinationals, big multinationals, but also pirates in this country who go against the tenets of the Bible and reap where they do not sow. Honorable Jaguar will tell you that for every shilling that he makes, the pirate makes 5 shillings out of his creative works. And as such, punitive penalties have to be instituted. Madam Speaker, I'd like to say that we would like to co-opt the ideas of creative bodies in this country. And as such, I'd like to ask this House to move with speed in forming the relevant committee, so that we can have these bodies coming before us and giving us their ideas on this Amendment Act, the Copyright Amendment Act of 2017. And these bodies do include and are not limited to the Kenya Association of Music Producers, the performing arts lobby groups, the film industry in this country, the digital content producers, who are very critical, Madam Speaker. I know when you walk in the streets of Nairobi, you're hearing new lingua out there. People talking about slay queens in this town. Slay queens are creation of social media and digital platforms, content creation. And let me tell you, it is an industry that can grow with all these bloggers out there, with all these amazing content creators online. What we need to do as this House is protect their ideas and make sure that they thrive from the art that they trade. Madam Speaker, I seek to retreat and put it on record that I do support this Amendment Act, and given the opportunity at the relevant committee, I shall be having some proposals of amendments that we shall be adding to this Copyright Amendment Act. With that, Madam Speaker, I support this bill. Thank you very much.
Thank you very much. Thank you. As you can see, that was on a certain date in December. The relevant committee has been created in Bunge, and that is the Departmental Committee on Communications, Information, and Innovation, and I happen to sit in that committee. So when this feedback comes back, it will be coming back to a committee that I sit in Bunge. Ladies and gentlemen, kindly welcome very warmly someone who has graced your screens, hard to believe, for 23 years. She's a performer on stage, she's an actress, she's a model, and I mean a model in the sense that she does appear in a myriad of many adverts in this country. And she's also a director, a founding director at the Performers' Rights Society of Kenya, which we call PRiSK. Please welcome the one and only, the lovely Irene Kariuki.
Thank you, Mheshimiwa. Thank you very much. Appreciate yourselves first and foremost. I've asked you to appreciate yourselves because it is a joy to see people who are interested to understand what the law has for them. Sorry, Mheshimiwa. What the law has for them. And why I say this is because for very many years, you'd find in seminars, in workshops, in gatherings where you'd ask people, or creatives, actors, actresses, musicians, we actually ask them, come and just listen what the industry has for you. Come and grow. Come and be knowledgeable in the industry. And you'd find a room of 2 or 3 people. So when I sit here and I see you, I'm actually feeling very blessed because you took your time out to come and be part of this great move. And even understand the laws that actually govern the very industry that you're in. So for that, for me, is a step in the right direction. And without so much, I'd like to first and foremost just give a brief introduction of Performers' Rights Society of Kenya. This is an organization that was established in the year 2009 and was licensed by Kenya Copyright Board and on behalf of performers. And when you look at the Act, when it talks about the Copyright Act, when it talks about performers, it wasn't a bit clear because we were thinking about, okay, because musicians had an organization, so performers in this sense will be actors. But when you demystify it further, we found that even singers, you go and stand and you get your microphone and you sing, you are a performer. And with that, we decided, let us all have open arms and we are all under one roof. And that is how PRiSK now represents singers, it represents the actors, and not just the singers, it also represents track producers, because by the time you get into a studio, and hello, those people who rap, hauna beat, lakini umeingia studio, na unataka utoke na mziki, si ni kweli? Then you force that track producer to create a beat for you. That person actually shares his intellectual property with you so that you can be able to have a finished product. Going back to Director Kasanga's years back then, we had those rhythm guitarists, we had the bass guitarists, the people who are behind the drums, but at the end of the day, who was recognized? It's either the person who owns the label or the person who is hard singing. But the person who is behind the guitar, the person who's behind the keyboard, or the person behind the drums was not recognized. And we say this is a performer, so this is a person who is supposed to be a member in PRiSK. And so that, in a nutshell, is the composition of people who are supposed to be members of PRiSK. What I'd like also to say is that the section of the Act that looks into the rights of the performer is Section 30. And for a very long time, and we know, if you are a performer and you do not have money from your pocket to get into the studio, the record label is the one who's paying for everything, so you do not own the master right. You signed a contract and you went. So whatever you are given by the producer is what you have, and you cannot ask for more. But what the Act has done when in Section 30A, which during the panel question and answer session, we will also tackle more, because it was introduced in the year 2012. Then a lot of things came up, a court case in Malindi, and it was struck off. But it is part of those sections of the Act that we are asking the government to consider to have them brought back into the Copyright Act. For you person who you do not have the muscle to go and actually say, I own this right, it is called the equitable remuneration right, whereby it is going to have you compensated for those people who are weak. They call them the weak, but I tend to believe in the creative industry, nobody is weak. Hello? Is anybody weak? By silence, you are weak. Are you weak? Oh, thank you very much. So I don't have weak people around, eh? Very good. So for you not to be considered weak, there's that element of that section that is going to be introduced back. Well, I'd like to speak a bit about that introduction back, because so many things happen, and I'd like people in this room with the information that you receive in this room, go out and be the ambassadors. Like we always hear, and our legal people here can tell us that ignorance of the law is no excuse, is no defense. True or not true? And it's upon you to start being interested, to read, understand, be part of the laws that actually affect you in your industry and in your craft. So when you read the Copyright Act, don't just read that section that actually just either represents your right or affects your right, but read it in entirety, read the whole of it, because one section could be saying this, the other section could be saying that. And part of the amendments is to look at such sections in the Act. What is it that affects me? Is there another section in the same Act that actually removes part of the rights that was signed to me in another section of the same Act? So when you have this and when you understand this, when you're arguing your cases, when you're going to sign your contracts, when you want to even speak authoritatively in your craft, then you have more muscle when you understand the laws that actually back you up. Not wanting to get so deep into the CMO because, like Mheshimiwa said, there'll be that question and the Q&A session. I'd like to pose a question to you, and just food for thought for the CMOs, because we know what has been happening in the industry. We are all cognizant of the fact that either because of lack of understanding, or I don't like putting it as ignorance, lack of understanding, you'll find you yourselves are actually being our enemies as the CMOs instead of supporting us. The question I'd like to pose is, what is my role in this industry? Am I here to build it? Am I here to demolish it? And what part do I play in the growth of the industry that I'm in? And why I ask this question is because you'll find most often than not, like Mheshimiwa has introduced, I've been in the industry for 23 years, faithfully. When my parents could not believe in the same industry, and I come from the era whereby if you're not a teacher, an engineer, a doctor, or a nurse, you're not working. Or an accountant, you're not working, so go and get a good job. Or go and actually look for jobs. But I thank God because over the years, now we are coming into this, the stage whereby, or the platform whereby intellectual property and your creativity is being embraced as a job. And the more consistent you are in it, then it becomes a profession for you, where you wake up every morning and say, I am a musician, I am a performer, I am a music creator, or I am a producer, and you be good at your craft. And that way, even the government will pay attention to us.
June, I know you can be an exciting unpacker of the law, so just unpack this law for us.
Thank you so much, Mheshimiwa. How are you all doing? Are we all here? Double Maths is your friend, I promise. So as you've heard, my name is June. And one of the things that I do, other than perform, I keep saying that I have a 8 to 5 and then I have a 5 to whenever. So during the day, I try and help fellow creatives like yourselves try and understand what rights they have. And this is one of the exercises that we were tasked to do as JGIP, is to try and pick out some of the things that were wrong or could be improved, rather, with this bill. And then in the evening, I'm a performer. So I want to sort of just briefly pick on something Irene said as I lead into this discussion. 2 years ago, I knew about the CMOs, but I was just involved with them.
Just say what CMOs are.
Oh, collective management organizations.
And what do they do?
They collect license fees and distribute royalties. So they are the three represented here by Bonali Kanyotu, Irene, and Dan Aceda as KAMP, PRiSK, and MPAKE. Now, I have been a stage performer for over 20 years. But then last year, I released my first album. That made my perception of this these organizations change completely. Why? Because now I can actually be a member of all three. I wrote songs, I composed them, so I can join MPAKE. I performed in studio as a vocalist, background vocalist. I can join PRiSK. I also paid for my productions. That makes me an independent producer, and now I can join KAMP. So I want us to think about the fact that in a few years, you could be me now. Right now, you may be doing your own performances, and it's fine, you're hustling, but the one day you own something, you don't want to then run and say, what was that session about? So take this opportunity to absorb and even go and find this thing on the internet and just read it. Because one day, and it could be very soon, I pray for most of you, don't wait 20 years like me. It could be tomorrow, but at least make sure you understand what they do and what this act can provide for you, because we're doing this for the next generation, and I believe you and I are there. These old people, you can leave them alone for. Anyway, so let me tell you very briefly some of the things that we picked out that we feel need to be considered by this committee. The first thing is harmonization. And what do I mean by that? I mean, copyright is one of three things that need to be considered. When you write this music, you sit under copyright because you create a piece of intellectual property work. But you as a performer, as an artist, a musician, you sit under the Ministry of then Culture, now Sports and Heritage. And then where your music or your audiovisual works is consumed sits under the Ministry of ICT. So one of the things we realized is that we cannot be having conversations in isolation. Like just those copyright people, let them go talk, and without involving and looking to see how this bill can speak to what is provided for under ICT and also under the Ministry of Sports and Heritage now. Each of you are actually playing under each of these three ministries. So the Communications Authorities Act, which is KICA, controls the broadcasters. So here I am, I've written a song, I'm represented under the Copyright Act. As a performer, as an artist, I'm taken care of by the Ministry of Heritage and Culture from a welfare and protection point of view. And then when I've created my product, they are now consumed on TV, radio, the internet. And those three people are regulated by KICA, the Kenya Information and Communications Act. So one of the things we proposed is, please talk to the three ministries when this committee is receiving, so that we don't have discrepancies. If a broadcaster has not paid for their license under the CMOs, that means they cannot legally use music or TV shows and other products you are creating. There needs to be a corresponding provision in their statute. So we put that all under the topic of harmonization. The next thing we raised is more for the public to recognize. Copyright is considered a private right. So nobody else can go and manage your copyright for you without you giving them permission. That means it's like your clothes that you're wearing now. If I like your shirt, I come and pick it. That's a problem, right? So you have to look at your right as a private right and understand that if somebody has infringed or stolen or done something with your property, it is your responsibility to raise the flag. The Kenya Copyright Board's mandate is not to go and police and keep watching and say, June, I thought somebody has picked your song. If you go and file a complaint with them, now that they're going to have a lot of money in their budget, they'll be able to go to court and fight this for you. So remember that the Act is giving you power to enforce your private right through the assistance of these organizations. So please remember that. The third thing, that we wanted to raise revolves a little bit more about the CMOs, and this was about something called a provisional license. The annual license that is provided by the Kenya Copyright Board is given to MPAKE, KAMP, and PRiSK every year. The reality on the ground is that December 31st, we are all on holiday. Yes? Except for you who are performers, you're somewhere on stage working like the good Kenyans that you are. However, on January 1st, if I don't have a license that has a January 1st date in my possession, there could be a question as to whether I am allowed to continue doing the work I'm supposed to do as a CMO. So one of the things we wanted to highlight was the introduction of a provisional license, which the bill has now proposed, so that you curb that problem of gaps. That your license expired December 31st, why are you coming into my shop to protect the rights of these Kenyans? So I think that's something that we are happy that the bill has addressed. We wanted to also raise the issue of discrepancy of language. As human beings, we use terminology the way it sounds like it makes sense in our head. But as lawyers, we're very particular about using the right terminology and harmonizing it. Why do I say that? Because if ever we end up in court, remember at that point in time, you're facing a judge who is looking at the letter of the law. And we cannot have a situation where in one place we say we are authorizing a copyright collecting society, and in 2 paragraphs down, it's now called a collective management organization. So one of the things we've noted throughout the Act is that there could be a better, improved way of harmonizing the language that is used. So when somebody talks about a CMO, you know what that is. And there's no question about, so is that different from a copyright collecting society? So the recommendation there is, can we use terminology that is across the board? There's also a discrepancy with the word certificate and license, but that's for my friend Paul to handle. There's the issue of private copy remuneration or blank media levy. Let me explain in very simple terms what this is. Every time we import blank CDs, blank DVDs, and I know we are talking to a generation that maybe doesn't own many CDs. Me, I have them. Even mine is on sale, so it's a little plug. Please buy it, even if you're in a cab, just tell the cab guy to play it, just to support June.
June umefungua duka?
Nimefungua duka, aki. Nimeona opportunity, wacha nifanye tu plug-in. I'm a creative also. But because these things still exist, there's still a risk of infringement through these media. Now we are saying, including the flash disks, the phones, the computers, as people are importing these things in, you must almost assume that there will be infringement. So what we are saying almost is like, because we know you're going to copy, Akis, you just pay us something when you bring these things at the border. This is what this clause in Section 30B is supposed to try and address. So our recommendation, because it's a bit summarized in the way it is written in the bill, is lengthen it a little bit and be clear. This is about private copy remuneration. Use even language. And it is collected because of this, and it is for the benefit of these people, and it can be collected by so-and-so. That is not clearly written at the moment in the bill, and we'd like to have that section revisited, and that's Section 30B. Finally, because I know I can feel the eyes on me, we wanted to just maybe make 2 proposals. One of them is in Section 46.5, is to give even more power to the members of these CMOs. Why is that important? Because right now, if you set up a company that is then licensed by the Kenya Copyright Board, it is allowed to go out into the public. If you own a restaurant, a bar, as Lee mentioned, the kind of people who use, you are then entitled to invoice them, ask them to pay you some money on behalf of the people who are your members, meaning all of us here. All right? Now, the challenge is, if that company misbehaves, what power do you have as its members to do something about it? You should be able to speak up. Why? Because the money being collected is yours. The one thing you must remember is that the company is there to collect your royalties. We even have limitations as to how much money we can use. So we wanted to add a phrase that says the collective management organization should be run to the satisfaction of its members. So if you have an actual true cause that you have a problem with, you should be able to say, before even you renew the license, Mr. Kekobo, I have a problem with 1, 2, 3 in this organization I belong to because they have my money. All right? I think you understand where I'm coming from with that, so I'm not going to go any further. And finally, the last thing I want to raise is the issue of calling what we call an assignment. And here I'm just going to do a brief definition. A license is a permission to use. So I know there's legal jargon that we get afraid of, and some of you have signed contracts saying, I license so-and-so to do ABC. Think of a license like paying rent. You live in an apartment or in a house or in an SQ that is not yours. Your landlord owns this thing, and they allow you to use it, to live there, to do whatever, within certain conditions that you get in a lease or a rental agreement. That is basically what a license is. You pay a certain amount every year or every month, if you're lucky, to continue living in this place. Now, you are the landlord where your work is concerned. So if you have a song, or you have a film, or you have a TV production, or whatever it is you who is the landlord. You're the one who can tell the person, I can give you permission to use this thing for this amount of time, for this amount of money, and you can do this with it, and you cannot do that with it. The opposite of a license is called an assignment. That means you have transferred ownership of the thing you own to somebody else. So some of you, and we've seen these contracts, you've come and said, I sold my right, I gave them, and then you still believe you own it. So that language in the Act, we want to encourage that it be clarified a little bit more, and that even as you're giving permissions to these organizations, the property is still yours. Do not sell your property. Retain your right, but give each of these bodies permission to go out and use your property to collect money for you. So I'll finalize there, Mheshimiwa, and I hope I've at least touched on some of the things. In the interest of time, there was more, but I hope that helps. Thank you.
Ladies and gentlemen, I want to open up this to the plenary session, and what I'll do is I'll allow you to ask your question, and if you can, please be direct about who you're directing it to, and preferably one question to one panelist. Please, if you have 2 or 3 questions, look for the one most relevant one. Don't combine 2 questions or 3 questions. Be direct, be precise, and I want my floor manager to be here with a microphone. And we are going to give the first session of questions to 3 people from the audience. And after that, I'm going to take 2 more questions. And I see your hand is up. I see your hand is up. Someone else? You came in late, so you'll go last. Is there someone else? There's the gentleman in the red shirt. So you'll come in the second batch of questions. And let's go. You start out by telling us what your name is and to who you're directing the question. Alafu ulize swali.
Good afternoon. Oh, hi, Jude. Okay, so my name is Songa. I'm a performing artist and a producer. First, I'd like to thank June and Dan for mentioning our intellectual property as land. Thank you. It really puts it into perspective. And you mentioned, this directed to June, you mentioned something about the blank media levy. Is there any way we can extend it a bit further? Because if we're just assuming, when people buy airtime, when people pay for Wi-Fi, we can also assume that they're going to be consuming this media. So is there any way we can include language into that bill that says, that includes levies in that area? Because we say that people don't pay for music anymore, but that's not true. They pay for music, but they just don't pay the artists. They pay the ISPs. So is there any possibility we can include terminology or language like that in the contract? Thank you.
Wow, that's brilliant. And I love the way you're thinking. If in the past blank media was what was used to carry what you're calling intellectual property, and it has been defined here as equivalent to land, or even I'll add to it a moti. You know, if I give you a moti, I'll charge you by the use that you're going to put it to. And I think it's a brilliant question, June. The second question, kindly.
My name is Felix Maringa. Again, the question directed to June. You are mentioning the gaps that are in the bill, and I'm just thinking about these creatives who come up with a very brilliant idea, and at some point in life they are not able to continue, maybe managing or handling it, maybe due to old age or due to sicknesses. So how can this bill be put up in such a way that even when maybe Dr. Kasanga is sick, then the family is able to actually take on whatever he brought to the industry? Yes.
Thank you very much. Good question. And I think, June, when you're replying to it, if I'm not wrong, it will go beyond the copyrights bill and go into how estates are managed for deceased persons, because I know estates can be transferred. The third question?
I'm George Gishona, and I'm a musician, I'm a songwriter, and a producer. First is to congratulate you for making it to Parliament. And we, as the music industry, would like to request you to represent our interests once, or rather, when you are there. My question comes to you. You have noted that the music industry belongs to more than 3 ministries. And us here, we have been fighting to have the music be under one single ministry. I think you can do something about it and place the music industry under one ministry.
Thank you for your questions. I'll start with Songa. I think I also like how you are thinking. Do I think it's possible? I'm not.
But wait a minute. Your name is Songa.
His name is Songa.
Like the Songa that has just been launched. Like the Songa you want to pay some levy.
Are these your government names? Are you known as Songa on your ID? Yes.
Yes. Like the Songa you want levied. Because your question was about levying the airtime and the Wi-Fi.
Yeah, so actually one of the proposals was to change the language to private copy remuneration, okay? Which A, does 2 things. It removes the word levy, because nobody likes levies and taxes, makes them feel like it's unfair, but that's from the point of view of the person paying. From the person who's possibly receiving this money, it's permission. So we're giving you permission to make a private copy for your use. That the Act allows. But if you make it and for some reason make some commercial gain from it, this is why this levy is being introduced. So if that's the definition, your question about including airtime, including other types of services, let's call them that, I think may have already sort of been tackled by the ISP regulations that have been introduced in this bill. We didn't focus so much on them because it was sort of like a music panel. But just to give you an example, an ISP, I think we all know, is an internet service provider, and anybody who's making accessible these works through a connectivity portal, let's call it that for now, to mass market, who then could potentially take your video off of YouTube and infringe, that they also now have a liability and a responsibility to not just sit and observe this infringement going on. So maybe the conversation might be how to fix the problem of the money going to the wrong people, as opposed to introducing a new levy.
A thing called compulsory copyright, where you pay in advance for what you're going to make. So I would really support Maringa's question, if that could be something we could consider for this bill, so that it's easier for people to have a structured way of exploiting our music, which at the end will make us more money.
Appreciated. Good questions. The question that was directed to me was about how do we bring everything artist, everything performer, everything musician under one roof. And, you know, from the top of my head, it doesn't matter whether it is a right or whether it is a trade or whether it is something that you own. There is hardly anything that sits under one single line ministry. There has to be something that is administered from laws that preside over one ministry, and other things about the same thing that are presided over by a law that is from another ministry. And that applies to almost anything that we engage with as an individual with government. Now, what probably is doable is something that June mentioned, which is a harmonization of the laws that cater for performing rights and the performers themselves. And that is possible. And in fact, there is an effort to doing that, where there is a harmonization of the different laws that are sitting in different places to harmonize them so that they can speak to each other. And this covers, it could cover the rights on it and also the offenses and penalties that come or whatever on the offenders. Am I right, June? Okay.
The artist, when it comes to the actor, has got a whole different scope. And if I remember on that particular recommendation that I saw, they had actually talked about a 5% resale right for anything above 20,000 shilling. Surely, every movie that we are shooting in this country does not have a budget of 20,000 shillings. So what we proposed was to have our resale right at 2%, 2.5%, that the broadcaster would be able to pay the CMO to collect on addition on our royalties. Now I know, Irene, now I'm coming from another docket. Now you sit at PRiSK and you also sit at KAG. So coming to you was first understanding how you work so far on collecting your royalties. Do you take the 80% that you collect from the broadcasters and make that and use that for your administration and 20% to share to all of us? Or which is the format that you have? Just as clarity for me to understand when I'm trying to push my 2.5, how would it work? Already, sir, we have already submitted to Parliament. It went in on time. We made the cut. So just in case now, that's how do we implement? We should be prepared. How would we work with that whole scenario? I will also throw something at you, probably a recommendation, that at PRiSK, could we have a department or a section that deals only with actors? That way it is clear. When you're paying your musicians, that is different. But then what happens there? What happens to my works? You understand? I think you understand where I'm coming from. So just a bit, throw some lights into that. Thank you.
There is a question that was directed to Irene, and this is the final question that we are going to take, and then I'm going to direct from there. Irene.
Okay, thank you very much. And to answer my national secretary of the Kenya Actors Guild, I'd like to answer your question in two ways, because the question is also in two ways. What has been lobbied and sent into the memorandum in the terms of the 2.5, and also we at the background as PRiSK, what is happening. First and foremost, to clarify.
The second one is specific to formula.
Yes.
She just wants to know what the formula is in terms of 80% share, 20% share, exactly, administrative, and what goes to the artist.
Yes. First and foremost, to demystify is that in 2013, as PRiSK, we set out to have the two departments you're talking about, to specifically have actors and to specifically have musicians on the side. And we started by the distribution rules. And the distribution rules are actually what govern us on how we are going to distribute back to our members the revenue that we have collected. And you will see that even when it comes to the revenue that we collect, yes, we collect it in one pot, but then there's a way we actually see how we've collected in the audiovisual sector. And the money we collect from the audiovisual sector is what goes to the actor, because this is money we go to users and we find they have television sets. So the baseline we've created in the distribution rules is this is money that belongs to actors. In as much as it is together with the money for musicians, any amount collected to users with only sound recordings is what goes to the musicians. So there's already a distinction of the money that has been collected for actors and the money that has been collected for musicians internally. In coming to the percentages, what is legally provided for is the 70-30, where 30% goes to administration, and then 30% goes to administration, and 70% goes back to the rights holder. What we are having is there are structures which have to be set, and it is true, and I sit here with a lot of humility in front of you to say, no CMO, none, even for the ones that have been in existence for more than 30 years, have ever been able to distribute at 70%. But internally at PRiSK, we are able to grow that percentage to 40% and administrative going to 60%. But there will be a shift within this year because in the past we've not been able to collect from broadcasters and we've not been able to collect from the transport industry, and broadcasters are actually the highest consumers of our works, especially as actors. So once we start getting that revenue, and there's not much which is being used to collect the same revenue, the tables will turn and you will find that more money is being given back to the rights holder vis-a-vis what is being spent on the administrative cost. So not unless there's anything which has not been clear.
You can't ask because I'm the moderator here.
I'm sorry,
Yes.
Mheshimiwa. Just to clarify on the last point on the 2.5% that you are pushing for. There are tariffs which are set. And these tariffs also go back to Kekobo for them to be taken to the Attorney General for gazetting. And it is that we collect revenue based on the tariff structure that we have. So what I would advise is to sit down and we restructure so that when we are going to the broadcasters, the 2.5% is included when we are collecting so that it is specifically there for distribution back to the rights holders. Yeah.
Guys, let's appreciate the panel with a big round of applause. And I'm just about to throw a curveball on, in fact, I'll just throw a curveball to Wakili. Wakili, get your mic. Just get your mic and if you weren't paid for this, ask something from Angela after this. And I'd like to just give a general vote of thanks. And if you're one of the organizers, one of the facilitators, one of the panelists, and those of us who've been able to participate in this session this afternoon, please just kindly give yourself a fitting round of applause. I'm totally and absolutely impressed by the turnout. Rarely do you find performers and generally Kenyans interested in the process of how laws are made. And as I told you, the Copyrights Amendment Bill has gone through the first reading in Bunge. It has gone through the second reading, and we are actually at the face of public participation. And that's why in the newspapers last week, there was an advert calling upon all industry players and any interested stakeholder to send in their memorandum by Tuesday. And we did receive memoranda, and I'd like to say that even from people within this building today, we got some good responses. And going forward, what will happen is that there will be an opportunity where the people who presented the memoranda will be invited to appear before the committee, the National Assembly Departmental Committee on Communication, Information, and Innovation to present, oral submissions of the recommendations that they are making. The curveball I want to throw at Wakili June Gachui. Yes. Wakili is what you do during the day.
Yes.
You're 8 to 5.
It is still during the day.
And then
at 5:01.
This is Badai. And what I want you to do is just belt out a song. Like a song of your own choice. And make sure it's something that we can sing along to. Oh, yeah. But you can do that thing worship leaders do where they throw. Hallelujah. You're allowed to do that. Yeah, okay. Yeah. Ladies and gentlemen, please give a fitting round of applause to the one and only, the very melodious June Gachui.
Thank you. Okay, so because we all have to do this work together, unless there's a hat going round, offertory ushers, please, if you would just remove the offertory basket, we collect something. So let me just teach you a chorus of one of my own songs. It's pretty simple. Is that okay?
Awesome.
All right. So all you need to do is, it's a new day. It's a good day. Can you try that? It's a new day. It's a good day. So when I point at you, that's when you sing that. It's very simple. Okay? Stepping out into the bright sunshine, not a gray cloud in the sky. It's a new day. It's a good day. So just put on your happy face. Yesterday's gone away. It's a new day. It's a good... Now, we're not in church, so I need to see you not just do... This one you can feel a bit of some sexy. Okay.
Dan is our beat master. Dan is our beat master.
Allowed,
He'll give us the moves. He'll give
so
us
if
the
we have
moves.
beatboxers,
Hapa hakuna kuodi wase. Hapa hakuna kuodi. Hiyo tuliacha 2017.
So just add, if you believe it's been a good day, then that's what the song is about. Okay? Sitting here thinking about the things that happened to me yesterday. Oh my gosh. See, I'm done wasting time. I've made up my mind to leave crazy behind and move on. So I'm stepping out into the bright sunshine, not a gray cloud in the sky. It's a new day. It's a good day. So just put on your happy face. Yesterday's gone away. It's a new day. It's a good day. Thank you, choir.
Whoa. One more time for June Gachui. Thank you very much. Thank you very, very much.